Okay, well, thank you very much, Jeremy. So, yes, the title of the presentation is Discipline, Why Bother? And I guess let's address two of the words there. One is discipline. What is discipline? I'm not going to really go into a lot of explanation about what discipline is. I'm going to sort of assume that there's some residual knowledge that I'm drawing upon. But for those that don't know, discipline is basically part of what's known as progressive discipline, which is considered to be um, a process whereby we try to correct employees' behavior in a systematic and accelerated approach such that termination of employment is not always the first answer to a problem concerning the performance of the employee. And so progressive discipline essentially involves a series of steps whereby the employer applies um, particularly measured responses to misconduct in the workplace through an aggravating scale, starting essentially with a warning and sometimes suspensions and ultimately termination of employment. The question, of course, is why bother to do this? And the reason why I ask the question is because we all know that discipline can be a real bother. Most employers, particularly supervisors and junior managers who have the responsibility for implementing progressive discipline, don't like to do it. And they don't like to do it because of the fact that it can take time and it is never a pleasant experience having to discipline somebody and tell them why they're not performing to the standard that you expect them to perform. And so we see that many a time supervisors and managers just don't do it in order to avoid these very uncomfortable human factors involved with it. And obviously, at the end of the day, it's our advice to our clients to make sure that, in fact, you do bother because it can benefit the employer and, in some situations, in fact, benefit the employee. So, we're going to discuss a number of subtopics this afternoon. I guess at the outset, I'm going to primarily focus my presentation on the non-union workplace. And the reason for that is most workplaces are non-union. B, even unionized workplaces have non-union employees. And so unionized employers will benefit from these discussions. And C, non-unionized employers are the most unfamiliar with the concept of progressive discipline since progressive discipline is institutionally embedded in the bargaining relationship between unionized employers and non-unionized employers. So I'll be going through how the discipline process intersects with the whole concept of just cause for termination. Whether and how the non-union employer can discipline an employee through a suspension process and when, if ever, that's appropriate. Then the actual perils of having a progressive discipline policy that is particularly robust that you may in some circumstances not actually apply and advising against that. Discrimination and how it intersects with the ever-present risk in employment situations of reprisal complaints and discrimination complaints, and how discipline is a fundamental process that will protect you from these very complicated and at times expensive claims of reprisal and discrimination. And then finally, in closing, I'll talk about a couple of interesting elements in the collective agreement context. So, discipline and just cause. At every conference like this, you'll hear about the McKinley case, which was a decision of the Supreme Court of Canada in 2005 that laid out the essentially the test and approach to terminations for cause that non-union employers had to follow in order to be absolved of the obligation to provide common law notice. And the upshot of the case is relatively simple, that a just cause analysis is always very fact specific of the particular employee's circumstances, what they've done, and a number of factors I'll talk about in a moment. The ultimate question is in determining if you have just cause, whether the employment relationship remains sustainable at the point of termination, and if it is, the employer lacks just cause. The McKinley approach is specifically calibrated to avoid being overly punitive with employees, even when they have run contrary to the employer's reasonable expectations, and requires a specific process in order to contextualize the seriousness of any particular employment-related circumstance. So in determining whether an employer has just cause, a number of factors are always considered, and that's obviously the seriousness of the misconduct and how it affects the employer or organization, whether in fact there was the existence of prior warnings or policies, and warnings are at the very heart of discipline, the employee's length of service, the existence of a disciplinary record, whether the employer has condoned the behavior that the employee has demonstrated, and condonation is essentially the employer looking the other way, allowing these things to happen before it corrects them, and whether the employee has expressed any remorse or apology with respect to the behavior they've engaged in. So discipline intersects with the idea of seriousness of the offense, and whether there's been some condonation by the employer. Obviously, where the employer has engaged in discipline for a specific type of behavior, it's easier to show the court that the conduct is in fact serious, because if it wasn't serious, the employer would not have disciplined. And it's effectively eliminates the risk of being found to have condoned the type of behavior you're dealing with. A recent case that kind of brings all of this home, all of these factors, and I think it's quite interesting, is a 2020 case involving Saputo Dairy Products. This case involved vaping in the workplace. The employee worked in a warehouse for Saputo, and Saputo was regulated by federal food safety regulations that prohibited smoking and vaping. And this was pretty serious stuff, that there are federal inspectors that go into food storage facilities, and if they find a violation of the rules, they can pull the licenses of the employer to sell food. And so the employer terminated the employee for having engaged in the vaping. It said that this was contrary to our no smoking policy and contrary to food safety regulations. The employee here admitted that he had been vaping in the warehouse. The employee's lawyer admitted that there was a policy that prohibited smoking in the workplace, but the issue was whether, in fact, the employer's policy prohibited vaping. And this will require you to sort of go back to 2017, when two things sort of happened at around the same time, which is we had the Smoking in the Workplace Act was legislated, and the advent of vaping as a substitute for smoking. Well, the Smoking in the Workplace Act specifically prohibited smoking and vaping, required employers to put up signs prohibiting smoking and vaping, and to have policies prohibiting smoking and vaping. But unfortunately, Saputo had just had a policy against smoking, but not vaping. And so the big defense the employee had was, well, he was vaping, he wasn't smoking, and therefore there was no just cause to terminate the employee. Ultimately, the court decided that, yeah, the employee's right. Yes, it's a big deal to be vaping in the workplace. Yes, the employer could have lost its license. Yes, it trained people about smoking, but it didn't specifically say that smoking included vaping, and therefore the employee should not have been terminated as a first offense. And the court in this circumstance, in passing, although it wasn't necessary to decide the case, basically said that the employer should have considered a lesser penalty that included a suspension. So the upshot for all of this is to demonstrate, I hope, that if the employer really thinks that a type of behavior is a big deal, it needs policies to specifically say, you can't do this, and it has to be really, really obvious about the things that aren't allowed. You can't just assume that a normal person with an average IQ is going to equate smoking with vaping. You have to communicate that to the employees. And if you haven't, termination as a first instance will not be upheld, and in that case, you should engage in some degree of progressive discipline. That case actually alluded to the fact that the employer may have wanted to consider suspending the employee in that situation instead of terminating him. But I think that was probably poor advice of the trial judge, because there is a lot of case law to demonstrate that employers should be very cautious about suspending employees that aren't covered by a collective agreement. And while the Atts case that I just discussed and the McKinley case do talk about employers needing to consider lesser levels of discipline prior to terminating an employee, there is still a long-standing history and chain of case law that suggests that employers that aren't bound to a collective agreement ought not to be suspending employees without pay. And the fundamental problem here is that when the Supreme Court was releasing its decision in McKinley, it was talking about just cause, and I don't think was adequately contemplating the decades of precedent concerning constructive dismissal. And so for those of you that don't know what constructive dismissal is, it's essentially a legal rule that says the employer can't unilaterally change the terms and conditions of an employee's employment without the employee's consent. And there is a fair amount of precedent that says that an employer's fundamental obligation to the employee is to pay them, and it's the employee's fundamental obligation to work. And so if the employer tells an employee, well, no, you can't work for a period of time and we're not going to pay you, that's been held to be constructive dismissal. The case that really brings this home was decided 8 months after McKinley, and is one called Karskelen versus FRI Corporation. Basically, it involved a management employee that got into a scrape with her employer at a trade show. The exhibit materials didn't show up. He got mad. She got a little bit shirty with him in an email, and he decided he was going to teach her a lesson and suspend her for a short period of time. The court held in that case the employer couldn't do that, and by suspending the employee, effectively constructively dismissed her, that he effectively fired her. And the court observed in that case that non-union employees can't challenge suspensions during the course of their employment. And therefore, there's something fundamentally unfair with making the employer the prosecutor, judge, and sentencing judge dealing with these sorts of incidents, when under a collective agreement, at least the employee could file a grievance and have the fairness of the suspension determined at arbitration. There's a lot of longstanding precedents from the early 20th century and throughout that says that the law generally does not recognize an inherent right to suspend. Here, the employer's policies did not actually indicate the employer was reserving that right, and so the employee was justified in leaving her job and suing for constructive dismissal. That case was appealed to our Court of Appeal here in Ontario, and it was upheld. So the upshot I think I'd like to leave you with today is, before you decide you're going to suspend a non-union employee, be very careful. It's generally something that I recommend clients definitely avoid for white-collar employees. For blue-collar employees, maybe consider very short suspensions with pay. And I acknowledge that it seems a little bit absurd to tell someone, okay, you get a day off with pay because you're so bad. And that in turn causes one to question the utility of suspensions at all. Also realize that if you think that you may have just cause to terminate the employee, you can suspend them at that point as a penultimate action before you go all the way to terminate. And it may be that if the employee quits, you will then at that point be able to say, well, we actually had cause to terminate them, but we wanted to avoid a long legal dispute with the employee. We wanted to give them another chance. And if you can show just cause, at that point, the suspension is likely to be upheld. But The upshot is to be very careful with respect to suspending employees that aren't protected by a collective agreement. Okay, sorry, I've been told that my pee is coming in a bit hot. So progressive, and it's good that I'm doing it with this one because the topic's progressive, perils of progressive discipline policies. So very timely intervention from our AV guy. Be very careful in creating progressive discipline policies for the non-union workplace that has a lot of process in it. Because once you do that, and if you fail to follow your policy, that will only come back to bite you. And I suggest that progressive discipline is a good thing. If you're going to have a policy concerning progressive discipline, make it one sentence, which is the employer will consider progressive discipline where appropriate, and leave it at that. Don't enumerate numerous steps that you're going to go through in order to engage in progressive discipline, because the moment you fail to do that, it's going to be used against you by the employee. Two cases make this point. The first is Johnson versus Swiss Chalet, a case from this year in the Small Claims Division of the Superior Court. This case involved a cook at a Swiss chalet who on Monday clocked out and then was told to mop the kitchen. The cook didn't think that was appropriate because he had clocked out and he left. The following day, he was given permission to leave early, but he left early without having made the fries for the evening, and that was a problem. And so on Wednesday, the manager and supervisor decided that they were going to give him a written warning, which is great. That's progressive discipline in action and should be done. Well, the cook didn't like it. The cook was a man. The supervisor and manager were women, and he thought that there's no way that he should be disciplined by the supervisor or manager. The big boss was the only person he believed that had the authority to discipline him. The meeting descends into chaos. The female manager uses the F word. He leaves crying. The supervisor cries later. The big boss gets on the phone and decides that he's just not following the rules and the authority of the supervisor or manager, so it's time to terminate the guy. In my opinion, this guy really did engage in atrocious behavior. Okay, he didn't make the fries. That's not good, but he should have behaved in less of an insolent and subordinate manner to his supervisor and manager, but didn't. But nonetheless, he finds a lawyer and they challenge the termination for cause. In this case, the court decides that the employer didn't have just cause, and it decides this because essentially the employer had a progressive discipline policy that required a verbal warning, a written warning, a written warning, a written final warning, and suspension, and then termination. Okay, so that's a lot of progressive discipline, and the most saintly employer would do that, but the ones in the real world that I know wouldn't do that. But the court said, if you're going to have a progressive discipline policy, if the employee's behavior doesn't amount to a complete destruction of the employment relationship, you have to follow it. And so it may feel good to write out a very long path of progressive discipline, but if you aren't prepared to apply it in every case, you run the risk of the whole purpose of the progressive discipline policy being vitiated, and that purpose obviously is to terminate for cause when you can. So Johnson versus Swiss Chalet is a cautionary tale. For those of you who want to know more about blanching fries too, very good case to read because it goes into details all about that. Next case is Wadalove versus a numbered company. In this case, there was not a lot of love between the employee and the employer that operated a bingo hall. This workplace was in a remote First Nations community. The bingo hall was ultimately supervised by a board of directors that was comprised of members of the band council. You get the feeling in this case that Mr. Wadalove was somehow connected to people who were on the band council before he got terminated, tolerated a lot of bad behavior. As evidence from his employment history, he was hired as the operations manager of the bingo hall in 2008, took a nap at his desk, got fired, but rehired the year later, and then was demoted to card seller and then suspended without pay in 2010, but the next year promoted above the rank of operations manager to the big job of general manager. Not really an employment history to convey a lot of confidence he was going to flourish in the role, but he did for 2 years until there was a new election, the band council changed, and the new members of the board started paying more attention to the complaints of rudeness that customers were giving, his absenteeism, his bad record keeping, poor cash controls, and they decided what the previous band council had decided 3 years ago, that this guy ought to be fired. So they did. Now, Mr. Wadalove's lawyer said, well, hold on a minute. You've got a progressive discipline policy, employer, and this progressive discipline policy requires coaching, verbal warning, written warning, final warning with possible suspension and termination. And you didn't go through all of that for each and every offense the guy did. And instead, you just gave him a written warning and a written warning, but not a final warning. And therefore, you couldn't terminate the man. And at the end of the day, he is found to have been terminated without cause, and the employer owes him damages for wrongful dismissal. Obviously, if this policy had not been in black and white and entered as an exhibit, he would have been terminated for cause because he had 2 warnings and he still didn't pick up his socks and would have been terminated. But the fact that somebody at some point thought that it was really good to lay out this railway track of steps that had to have been followed for each and every step resulted in the whole purpose of progressive discipline being frustrated. So as we often say in our practice, no good deed goes unpunished, and the employer needs to be very mindful about enacting these kinds of policies that go into that granular bit of detail. So this is the point in the presentation I ask, why would anyone ever be willing to engage in a process of progressive discipline? What's the purpose of doing it? Why bother? And the reason why we have progressive discipline, I would suggest, is not to save some money with respect to not-for-cause terminations, but it's to protect yourself against other things. And those other things are allegations of discrimination and allegations of unlawful reprisal. We know that under the Labor Relations Act, an employer that terminates an employee for exercising their rights under the Act commits an unfair labor practice, and the law specifically has a reverse onus that requires the employer to actually prove that its decision to terminate or discipline an employee was not motivated by anti-union animus. And so the onus is on the employer to actually prove that its decision was beyond reproach. Employers that terminate employees without having any degree of discipline routinely run afoul of this obligation, and in some situations find themselves certified by the Labor Relations Board for basically overreacting to discipline-related issues. This reverse onus can also be found in the Employment Standards Act and under the Occupational Health and Safety Act, where an employee has the right to be free from any reprisal relating to them having engaged or pursued their rights under both pieces of legislation, and where the employer where the employer takes action against the employee, it has to prove that that action is entirely unrelated to the employee having engaged their rights under the ESA or Occupational Health and Safety Act. This was brought home in a case from 2020 involving Huawei Technologies and Mr. Morin. The upshot of the case really is that the employee had a bad history of employment, was rated as a C-grade employee. The employer was fed up with his poor performance, went to HR and said, we want to fire the guy. HR said, well, you got to do the progressive discipline. So they did. They wrote him up, and the following day, he started a harassment complaint against the employer, claimed emergency leave while he stayed at home and sulked. And when he came back to work, the employer wanted to fire the guy. But having received this harassment complaint, it then retained a lawyer, investigated the complaints, and ultimately terminated the guy. Now, again, this fellow found himself in the clutches of a very aggressive plaintiff side lawyer who decided she was going to make a name for herself by alleging the employer had terminated this fellow because of his having filed a harassment complaint and taking an emergency leave day to sulk. And at the end of the day, the employer was vindicated because it could actually prove that it engaged in the performance appraisal and had actually issued this man the discipline before he filed these complaints. And it can also prove that it had decided to terminate the gentleman before he filed these complaints. And therefore, the employer was able to rebut the presumption that it had engaged in a reprisal under the ESA and under the Occupational Health and Safety Act. So in these circumstances, the employer terminated him without cause, paid him out, but still it had to defend its decision because of these accusations of reprisal. The biggest issue that we often see in termination situations is the fear that the employer is going to be accused of having terminated for unlawful discrimination under the Human Rights Code. And so the Human Rights Code basically protects the sick, the disabled, racialized people, people on the basis of their religion. And so many times our clients have to be concerned that when they terminate somebody, they'll be able to defend an accusation that they have engaged in behavior that is unlawful and contrary to the Human Rights Code. Now, to deal with that situation, you have to understand how discrimination is proven before the Ontario Human Rights Tribunal. Discrimination is a insidious practice that is very difficult to prove for someone who feels that they have experienced discrimination. No one puts up their hand and says, we're firing you because you belong to this particular group, because you have this particular religion, or because you have a disability. So people that are believe that their rights have been violated have a challenge in proving discrimination. Now, the leading case on this issue of how you prove discrimination is the Peel Law Association versus Peters. And this is a very interesting case that involved two lawyers and an articling student that went into a courthouse law library and were asked by the librarian to produce their bar cards to show that they were in fact lawyers and able to access the library. The librarian only asked these two lawyers and articling student for their bar card and nobody else in the library. And the evidence was that the articling student and the two lawyers were both Black lawyers. One of the lawyers and the articling student had dreadlocks, and they were the only one asked. And in that situation, they complained that this was discrimination, that they were singled out. The case turned on the fact that the librarian actually didn't have a coherent answer to why she asked these people for their bar cards. And the case got litigated through the Human Rights Tribunal, the Divisional Court, and the Court of Appeal, which ultimately had to decide, how do you prove discrimination here, right? It smells like smoke in this situation. Do we conclude that there's a fire? And it came down to essentially the librarian didn't have a good answer to why she asked. And just like in medical malpractice cases, where the doctor is the one who knows why the Patient died or suffered these medical complications and the patient didn't, it's not up to the patient to prove why the doctor did what the doctor did. And so in any discrimination case, the employer in the employment context is well advised to be able to prove why it's terminating somebody and to indicate that the employee was a problem employee all along. And that's why they terminated the person, not because of a disability or identity in a specific group. Last case I want to discuss, which really brings all of this home, is the case of Oswald versus video technology. Terrible case involving a young lady who was in her first office job, goes to the job interview and tells the employer that she wants to start a family. She's trying to get pregnant. Employer's hiring for a receptionist job, hires her. That's no problem. She comes to work for a few months, and then one day she has a miscarriage at work. She goes home on the Friday, comes back to work on the Monday after the miscarriage, feels pain, goes to the hospital, needs surgery, back at work on Thursday, and she's greeted with a termination letter for absenteeism. The employer in that case built its defense on the allegation that the employee was just a terrible employee. She was surfing the net the whole time in the first 2 months of employment, would always be on the phone with her mother. Often her mother made her cry and she would have to leave the switchboard in order to recover. No doubt I have some sympathy for this employer, because this was a new person to the labor force, new person in the office environment, seemed to be a pain in the neck for the time that she was there prior to her miscarriage. But the problem was the employer didn't discipline the employee for any of these circumstances. And so the employer couldn't rebut the presumption that it had engaged in discrimination. And had it engaged in what employers often feel uncomfortable doing, giving a written warning, telling employees their expectations, and putting it in writing, is what should have happened and would have insulated the employer from a very unpleasant discrimination case that they lost. So I hope at the end of the day, I've answered the question, why bother? If we have any questions about the collective agreement context, I'd be happy to answer those in our question and answer period. And I want to thank you all for your time and attention.
Thanks, Jeff. I think we all heard loud and clear, especially with that last case, why